So now we come to another very important concept under the law of contracts, a very special form of contract that is something you will see daily, right, in your relations with, let us say, your dry cleaner. Okay, you see these glasses. Okay, these glasses were the subject of a bailment. Sir, what are you talking about? Why are your glasses involved in a course on the law of contracts? Let me tell you. A month or so ago, right, I used these frames. Okay, right, I took these frames belong to my mother. I took these frames, okay, and I went to the optometrist, and I told the optometrist, basically, check my power. He checked my power, okay, and then I went to Titan Eye Plus, which is the sort of a brand of glasses, right, specs makers, call them what you will. So I went to them, I gave them these frames and said, hey, these frames belong to my mother, but of course the lenses have her power. Okay, I want you to replace the lenses. Here is my power, basically. Okay, and I want you to replace my mother's lenses with my lenses so that I can use these glasses and use these glasses to deliver the lectures. So I left these frames with the Titan Eye Plus showroom, okay, for a couple of weeks. I had to rush back to Bangalore, okay, because of a bit of an emergency. I couldn't collect these glasses for a period of 2 weeks. Okay, so I came back 2 weeks later, okay, and he handed over the glasses to me and he said, the lenses are here. All right, I've replaced the lenses. Here are the glasses. He kept them for 2 weeks. He asked me to come back in 3 days. Okay, in the meanwhile, while I was in Bangalore, I got a call from him about 3 or 4 days after I had left the frames with him. He said, sir, we have replaced the lenses, but the lenses are faulty. We've just done our tests and the lenses are faulty and we're going to need another week to get new lenses. I said, okay, go ahead, keep the frames with you. In any event, I can't come back from Bangalore for a period of 2 weeks. Great. Okay, so I go back after 2 weeks and like I said, they hand the frames over to me. Okay, let's assume that I come back after 2 weeks and they say, sir, you had to collect these frames after 3 days. Then we called you up and said that the lens were defective and we said we need another week. Then we called you up after 10 days and we said, sir, your glasses are ready, you can collect them. You didn't come for 4 more days. Basically, you made us wait for 4 days. So in the interim, we've got rid of these frames. I said, what do you mean? They said, sir, we're a very busy store. We're a very big chain. We don't have place to store such frames in our, we don't have place to store frames for more than 2 days after we ask the customer to come and collect it. Basically, okay, there you go. Sir, what does this have to do with the law of contracts? Well, everything. Because in this scenario, what have I affected? I have affected a bailment. I am the Bailor. Okay, basically, and Titan Eye Plus is the Bailee. Okay, what is a bailment? What is a Bailor? Who is a Bailee? Right? Let's find out. Let's read section 148. It's on your screen. Okay, so under section 148, okay, bailment, Bailor and Bailee are defined. A bailment is the delivery of goods. Okay, so I've delivered the frames by one person to another. So I have delivered the frames to the person in charge of the Titan Eye Plus showroom for some purpose. What is the purpose? To replace my mother's frames with my frames, with lenses, that replace my mother's lenses in the frames with my lenses, with my power, basically. Upon a contract that they shall, when the purpose is accomplished, be returned or otherwise disposed of according to the directions of the person delivering them. Therefore, right, what is the purpose? The purpose is to put in fresh lenses. They've put in fresh lenses. Once they've put in fresh lenses, they have to return the frames for me. Return the frames to me, I beg your pardon. Okay, the person delivering the goods is called the Bailor, so I am the Bailor. The person to whom they are delivered, that is the manager of the Titan Eye Plus showroom, is called the Bailee. The Titan Eye Plus company is the Bailee. And the explanation is, if a person already in possession of the goods of another contracts to hold them as a Bailee, he thereby becomes the Bailee and the owner becomes the Bailor of such goods, although they might not have or may not have been delivered by way of bailment, although they may not have been delivered by way of bailment. Okay. Pause it, read it carefully. I'm back on screen. So another classic illustration I'm going to give you is that of the dry cleaner. Okay, you take your suit, okay, a big wedding is coming up and you're going to wear your best suit to the wedding reception. You take the suit to the dry cleaners. Okay, you go to the dry cleaners and you say to the dry cleaners, I'd like this suit dry clean. He says, sir, the dry cleaning this suit is going to cost you 500 rupees. You say, what, are you crazy? No way I'm going to pay you 500 rupees, and you leave from there. You are so upset, you are so indignant, right, with rage. How can he charge 500 rupees to dry clean a suit? You've forgotten to pick up your suit, in the sense that you take the suit to the dry cleaner shop, you keep the suit on the dry cleaner's table, you say, how much to dry clean the suit? He says, 500 rupees. You say, are you crazy? Take a walk, take a hike, I'm not going to pay you 500 rupees, and you storm out of the dry cleaner store. Basically, the suit is on the counter. You've forgotten the suit there. Okay, the suit is now in the possession of the dry cleaner. Is that a bailment? Obviously not. You have not delivered the goods to the dry cleaner. So he's not a bailor, you're not a bailee. What have you done? You have basically left your goods there. You have essentially lost your suit. You have left it there. Who is the finder of the suit? The bailor is the finder of the suit, basically. So this is the relationship of an individual who has lost his goods and the dry cleaner is the finder of the goods. So when the dry cleaner says, oh, he's left the suit here, he has found the goods. It's not a case of bailment. Okay, we'll come back to the rights of a finder of lost goods towards the end of this lecture. But I want to take this analogy further right now to explain, or should I say to illustrate the explanation to section 148. The explanation to section 148 says that you may consequently become a bailor and a bailee. It may consequently become a bailment if, although originally not delivered for the purposes of a bailment, right, subsequently the conduct of the parties indicates that it has taken the form of a transaction of bailment. How does that happen? So he calls you up on the phone. He says, sir, aapne suit yahan chhod diya hai. Sir, I have found your suit, or should I say, you have left your suit on my table. You walked out, you stormed out, the suit is here. You say, oh, thank you, I'll come collect it. But the dry cleaner says, sir, I know aap upset hai, I'll tell you what, I will dry clean this suit for you for 400 rupees. You say on the phone, okay, that's very kind of you, and you tell the dry cleaner, fine, dry clean the suit for 400 rupees. He dry cleans the suit for 400 rupees. Okay, then you come 2 days later to collect the suit. And you ask him, where is my suit? You say, sir, galti ho gayi, I made a very big mistake. Basically, I gave your suit away to the wrong person. I gave your suit away to the wrong person because there was a mix-up. Okay, another person had left his suit. I thought that was your suit, basically. And he basically took your suit instead of his. There's been a basic colossal mix-up. Okay, he says, sir, what's happening? Simple. You go to the dry cleaners, you want a suit dry cleaner 500. He says, no way, I'm dry cleaning 500. You storm out of there, but you've left your suit behind. Then he calls you and says, I will do it for 400. You say, go ahead, do it. So because you say go ahead and do it under the explanation to section 148, although originally not delivered for the purposes of a bailment, subsequently it becomes a contract of bailment. Okay, then what happens? Another customer leaves his suit behind. There is a mix-up and your suit is given to that other customer. And that other customer's suit is given to you and is left behind. And you say, this is not my suit. When you go there and he says, sir, galti ho gayi, there's been a mix-up. Your suit has been given to somebody else. Your goods have been lost. You have lost those goods. The dry cleaner is not able to track down the person to whom he gave your suit. He says he never left a number. He never left any details. I gave him the suit. He has to come back. I hope he comes back, but he hasn't come back. It's been 24 hours. Then it's 72 hours. It's 96 hours. 5 days pass. A week passes. He doesn't come back. The suit is as good as lost. So you are the bailor. He is the bailee. Okay. You left the suit there, though not originally for the purpose of the bailment. Subsequently, it becomes a contract of bailment because you say, go ahead and dry clean my suit for 400 rupees. Right. So that is the relationship of bailment, and the bailor in that case, that's you, have all the rights available to a bailor under the Indian Contract Act, and you can enforce those rights against the bailee. And his loss of those goods will give rise to liability towards the bailor on behalf of the bailee. So the bailee has a right, has a duty, I beg your pardon. The bailee has a duty to ensure that the goods are taken care of, and when the goods are lost or damaged, when in the exclusive possession of the bailee, the bailor may enforce certain rights and remedies against him, and the bailee will have to compensate the bailor for the loss of the suit. So he will have to pay you to the value of the suit. The court may very well take into account that it was an old suit, right, that it had depreciated in value, etc., etc. But you will have to lead evidence to say this was a Raymond suit that I had specifically stitched, custom-made suit for 25,000 rupees. I had been using it for 3 years, so the court might say, okay, we will award you 15,000 or 20,000 rupees. So every day you have relations of bailor-bailee. When you go to watch a movie, what do? Usually you go in your car. You park your car in the mall. That is the relationship of a bailor and a bailee. You are the bailor and the mall is the bailee, basically. Right? The company that owns the mall is the bailee. Alright? It's as simple as that. So they have a duty to take care of your car. It is in their exclusive possession in the parking lot. What happens if your car is stolen? This was exactly what happened in the case of New Assurance India Private Limited. I beg your pardon, not private, New Assurance India Limited versus the Delhi Development Authority, 1992 Delhi High Court case decided by Justice Wadhwa. Let's look at the facts of that case, and after the facts we will look at Justice Wadhwa's elucidation of the law pertaining to bailment, and he undertakes a very, very helpful and informative survey of the provisions relating to bailment under the Indian Contract Act. That case is now on your screen. Okay, so New India Assurance versus DDA 1992. All right, the plaintiffs contend, okay, that the defendants were responsible for the safety of the truck and were bound to deliver the same to the plaintiffs in the same condition in which it was parked in the parking lot under the control of the defendants. So basically, right, the owner of a truck has parked the car in the parking lot of the DDA. That truck, however, mysteriously, unauthorizedly and illegally was removed from the parking lot, i.e. it was stolen. On account of the negligence of the staff of the DDA, basically the parking attendants were negligent, right? At the site there was a parking receipt, okay, and the parking receipt remained with the DDA parking staff, okay, basically. All right, I beg your pardon, still remained with the plaintiffs, that is the New India Assurance, which is pursuing a case against the DDA for the theft of the vehicle, basically, of the assured, of the individual whose car they had basically assured. All right, the plaintiffs therefore say they are entitled to the amount of rupees 2,91,500 being the cost of truck, okay, being the cost of the truck. All right, so parking receipt is still with the driver of the truck, right? The parking receipt is still with the driver of the truck, but the truck is parked in the DDA parking lot. Okay, there were attendants there, parking attendants who worked for the DDA, servants of the DDA, basically employees of the DDA. They were negligent, which led to the truck being stolen. There is no rebuttal by the DDA, except that it was argued on their behalf that possession of the truck always remained with the second plaintiff, in as much as the driver of the truck, that is the second plaintiff, was sleeping inside the truck, and it is only when he had left at about 3 a.m. on the night of 8th and 9 June 1987 for the purpose of drinking water that the truck was stolen. And further, right, the defendants claimed, the DDA, that there was no contract between the parties under which the defendants were bound for the safety of the truck, Pause it, read it. I'm back on screen. Of course, there was a contract, sir. This is a contract of bailment, isn't it? The second plaintiff, the driver, has gone and parked the car. He has paid the parking fees. The receipt is with him. Okay. Although he's in the truck and he has gone for a drink at around 3 a.m., the truck has been stolen. So how can we say, sir? You could say conversely, why shouldn't the driver be held responsible? Shouldn't he look after the truck? The other argument is, no, sir. The driver should not look after the truck. The DDA should look after the truck. That's equivalent to saying, when my driver parks the car in the mall and he goes out to have dinner while his employers are watching a movie and the car gets stolen, you can't blame the driver, sir. Right? The blame has to fall on the on the parking lot attendants of the mall. Exactly. That argument is the correct argument. Justice Wadhwa reaches a similar conclusion, but before doing so, he looks at the relevant provisions relating to bailment. They're on your screen. Okay, so what are the relevant provisions? We're looking at sections 148, 149, 151, 152, 160 and 161. Let's start. Plaintiffs submit that in the facts of the case there was bailment and the defendants were the bailee of the truck, and as bailee the defendants were bound to take as much care and safety of the truck as a man of ordinary prudence would in the given circumstances. And it was the duty of the defendants as bailee to return or deliver the truck to the plaintiffs before the expiry of the period of 24 hours as per the receipt issued to them by the defendants, and since the truck was not so returned or delivered at the proper time, the defendants were responsible for any loss occasioned to the plaintiffs. Absolutely right, the argument by the plaintiffs, right? And their argument is covered under section 148, wherein a bailment is defined as a delivery of goods by one person to another for some purpose upon a contract that they shall, when the purpose is accomplished, be returned or otherwise disposed of according to the directions of the person delivering them. The person delivering the goods is called the bailor. The person to whom they are delivered is called the bailee, right? So the DDA is the bailee, the driver of the truck is the bailor. Under 149, now we come to the provisions of 149. The delivery to the bailee may be made by doing anything which has the effect of putting the goods in the possession of the intended bailee or of any person authorized to hold them on his behalf, basically. Pause it, read it carefully. I'm quickly back on screen for 10 seconds. So there has to be delivery. Okay, the delivery may be actual or constructive. We're coming to that point, but there has to be delivery, and the consequence of the delivery has to be to put the intended bailee in possession of the goods. Let's return to the other relevant provisions before we look at the issue of constructive delivery, actual delivery, and exclusive possession. On your screen, next slide. Okay, section 151 prescribes that in all cases of bailment, The bailee is bound to take as much care of the goods bailed to him as a man of ordinary prudence would, under similar circumstances, take of his own goods of the same bulk, quality, and value as the goods bailed. Then, under section 152, the bailee, in the absence of any special contract, is not responsible for the loss, destruction, or deterioration of the thing bailed if he has taken the amount of care of it described in section 151. So 151 and 152 expands upon the duty of care that the bailee has to take of the goods. 151 says that he must take as much care of the goods as bailed to him in the given circumstances as a man of ordinary prudence would. The test is what care would a man of ordinary prudence have taken in similar circumstances. So what are the circumstances here? Basically, the truck has been parked in the DDA parking lot. What measures would a man of ordinary prudence take to ensure that the truck would not be stolen? He would basically, okay, let's delve into this a little further. I'm back on your screen. So what would he do? Basically, he would lock the gate. Obviously, there would be a parking entry. There would be a barrier. So now you have these fancy automated barriers. Back in 1992, you didn't have that, basically, right? What would you have? You would have DDA parking attendants standing at the entrance. And in fact, if you still go to places like Nehru Place, yeah, the parking next to Nehru Place in Delhi, those of you are Delhiites, so those of you who have been to Nehru Place in Delhi, you will see that the DDA controls parking. You go to Khan Market, there are no fancy barriers, right? You park the car, your car is at the mercy of those parking attendants, but you're paying them 20 rupees, okay, they're giving you a parking receipt, the parking receipt is in your possession, you have left the car there as well, you have delivered possession of the car, okay, to the bailee there, all right, the bailee being the representatives of the DDA who are looking after the parking. All right, so I don't know if it's the DDA that looks out of the parking. I'm sorry, the parking there would be looked after by the NDMC, right? I guess the Khan Market would come under NDMC, the New Delhi Municipal Corporation. Depending whichever area you have parked in, the municipal corporation in charge there would look after the parking also. So they would be the bailies. Okay, what care should they take? Obviously, enough attendance. They should make sure that theft does not occur. Basically, they need to keep an eye on the cars. So you park in a mall, you know that you have an entry and an exit. The entry barrier is now automated. So you have to basically, if you're stealing a vehicle, you have to smash through that because they will not release the vehicle without you producing a parking receipt. Unless you produce a parking receipt, okay, and you pay the amount, they're not going to let you go. So these are some of the measures that they have to, that a man of ordinary prudence would take in given such similar circumstances. That's section 151. Let's go back to 152. It's on your screen. So what does 152 say? The bailee, in the absence of any special contract, is not responsible for the loss, destruction, or deterioration of the thing bailed if he has taken the amount of care of it described in section 151. So in the absence of a special contract, basically, right, and just pause it, read it, I'm back on screen. Under a special contract, okay, you might say that there's a heightened duty of care, okay, imposed upon the bailee. So we have these long-term parking, right? So we have long-term parking in the airports. So I hail from Bangalore. Bangalore is my hometown. There have been instances where I've parked my car in Bangalore for a period of 24 to 36, maybe in 48 hours in the long-term parking. Basically, in such a scenario, okay, is there a special contract? Okay, so the parking receipt will have the terms and conditions. If there is a special contract that basically the because of its long-term parking, okay, the bailee of the goods, basically that is the parking attendants of the Bangalore Airport Authority there, okay, basically who runs that airport? Yeah, I don't think GVK runs that airport, but I think the airport is run by an authority constituted to run the airport, basically, right? So it's a public-private partnership, if I'm not mistaken. So the entity that runs the airport will be responsible for the care of my car, but it could be that there is a special contract, okay, long-term parking, okay, it could be a special contract. It all depends on the parking receipt. That is your evidence of the terms and conditions on which the goods have been bailed. If there is no such special contract, then the long-term parking, right, the measures they take in the short-term parking will also apply to the long-term parking. What is the measures? Basically ensure that the car doesn't get stolen, basically. Okay, now in Bangalore, something that worries me a lot about long-term parking is that there is no covering, there is no shed. So I wonder if I leave this here for 36 or 48 hours, there's going to be so much dirt, and not just dirt, if it rains, if there is hail, okay, the car is exposed, basically. Okay, so when I park the car, okay, I might say, and I leave the car there, I come back after 48 hours, there's been a massive hailstorm in Bangalore, and because of the hailstorm, the glass is shattered, the car is damaged. Can I hold the bailee responsible? Would a man of ordinary prudence in similar circumstances have put a roof over the car? He might very well argue that when I parked the car, I knew that I would not, there would be no covering, basically. Okay, so that was within my knowledge. So it would have to be litigated in a court of law. So these are the considerations. See how complex a simple act of parking your car, okay, in long-term parking what kind of complex scenarios it can lead to, basically. So this long-term parking is a kind of special type of bailment, basically, and if there is a special contract governing that, then a higher duty of care is imposed on the bailee. If not, it's the simple care that a man of ordinary prudence in similar circumstances would take. So the measures he takes in short term, he will also have to take in long term. It's as simple as that. That's what 151 and 152 are getting at. Let's go back to the slide. It's on your screen, okay. Justice Wadhwa also refers to 160. Okay, and he says, it is the duty of the bailee to return or deliver according to the bailor's instructions the goods bailed without demand as soon as the time for which they are bailed has expired or the purpose for which they were bailed has been accomplished, basically. And under section 161, if by the fault of the bailee the goods are not returned, delivered or tendered at the proper time, he is responsible to the bailor for any loss, destruction or deterioration of the goods from that time. Okay, it's as simple as that. Pause it, read it. Okay, I'm back on screen quickly. So the basic test is exercising a reasonable care that a man of ordinary prudence would in the similar circumstances. Under sections 160 and 161, it's stated that once the purpose for which the goods have been bailed has been achieved, has been accomplished, they must be returned. They must be returned to the bailor. But what happens, right, if the bailor cannot come and collect the goods immediately? So the bailor, okay, he parks the car. Okay, the parking, he says, I'm taking long-term parking. So when you enter the long-term parking lot in the Bangalore airport, they will ask you, sir, how many hours are you going to park for? I say 24 hours. They give you a receipt for 24 hours and they say, sir, after 24 hours, right, you cannot park the car here. You must come and remove the car. Okay, so after 24 hours, without any demand, they must give me the right to take the car away, basically. Okay, or if I come before that, I can take it away. At the expiry of 24 hours, they will say, sir, please remove the car. I don't remove the car. Basically, my flight gets delayed and I come back after 36 hours. What will they say? Sir, we're going to charge you for the 12 hours. We're going to charge you the parking fees for the 12 hours, basically. Okay, so if the goods, right, the bailee is willing to return the goods and the bailor is not there to collect the goods on time and the bailee has to incur some extra expenses, that, right, the bailor becomes liable for that, and therefore that extra cost of those 12 hours of parking are actually the cost that that is being incurred by the bailee in storing your goods beyond the contractual period. You have paid them 400 rupees for 24 hours of parking, and then you have parked there for an extra 12 hours, so they charge you a further 200 rupees. Okay. Under the Indian Contract Act, in the bailment provisions, the bailee is entitled to such costs and expenses. Okay, we're coming to those provisions down the line, but I'm just saying this in the context of section 160 and 161, right, to highlight the fact that there are instances where the bailor is not able to take delivery of the goods from the bailee once the purpose is accomplished. As long as the bailee is ready and willing to return the goods upon the expiry of the time for which the goods were bailed, right, for the time, the duration of time for which the goods were bailed, the bailee has discharged his or her duty. Okay, so in the case of my glasses, Titan Eye Plus were well within their rights to say, we had to store these glasses for 3 or 4 days more than the period originally agreed to, and you have to give us some charges for storing these glasses. Of course, they won't do it. It's bad customer relations, right? Basically, I will never go back to them. They don't want to lose a customer because they had to keep a small little frame for like an extra 3 or 4 days. They won't do it, but by law, they had the right to do it, and they're not going to go to court and enforce that, obviously, right? But the situation is different when you have a case where a truck is stolen. For example, the truck is stolen at 3 a.m. and the parking receipt was well beyond that 3 a.m. time. So the goods have been stolen while in the exclusive possession of the bailee. Okay, when the bailee had a duty to return those goods. That's exactly what's happened, right? So the waters are muddied here in this case. So the fundamental question Justice Wadhwa has to ask is, did the Delhi Development Authority, who essentially had domain over the parking lot, who owned the parking lot, who were the bailee of the goods, that is the truck, did they exercise the care expected of a man of ordinary prudence in similar circumstances? Let's go to the finding of Justice Wadhwa on this. It's on your screen. Okay. So he relies on the case of Srinivas Iyer versus the New India Assurance Co. Limited, a similar, very similar in terms of the facts. Okay, plaintiff's car was insured with the New India Assurance Company. Car suffered damage in the accident, and under the policy of insurance, the insurance company took the car to a repairing workshop. While the car was at the workshop, okay, a fire occurred and the car of the plaintiff was destroyed. Okay, so very, very unlucky plaintiff. His car first is injured in an accident and then it is completely destroyed in a fire at the workshop. The insurance company's representative took the car to the workshop under the terms of the policy of insurance. And the court was of the view in Srinivas Iyer that the insurance company, having taken possession of the car, was a Bailee and the repairer was a sub-Bailee. So the repairer was a sub-Bailee of the original Bailor, that is the owner of the car. And in Srinivas Iyer, the court held that the burden was on the Bailee and the sub-Bailee to establish to the satisfaction of the court as to what degree of care was taken in respect of the damaged car, and the same having been not discharged, the learned judge was justified in accepting the evidence of the plaintiff and recording the finding that the Bailee and the sub-Bailee had not taken care or taken such care of the car as was expected of a prudent man in respect of his own goods of the same quality and value. The court held that the Bailee was liable for the loss suffered by the plaintiff, the Bailor. The plaintiff had led evidence in that case that the car had been kept in a careless manner in the workshop where inflammable material was kept, basically. Okay, all right guys, so it's as simple as that. They did not exercise reasonable care as a matter of ordinary prudence in Srinivas Iyer versus New India Assurance Co. The car was burnt down essentially. You kept it near inflammable material, the fire hazards, right, basically, and the car was destroyed. Therefore, both the Bailee of the goods, that is the insurance company through its representative, and the sub-Bailee of the goods, that is the owner of the workshop, were responsible to the Bailor, the owner of the car, and would have to basically compensate him for the loss caused. More on that later. For now, let's just look at what Justice Wadhwa concludes on the facts of New India Assurance versus DDA, the 1992 case, and that's on your screen. He concludes that the DDA was negligent. He concludes that the DDA did not exercise reasonable care. And in reaching that conclusion, he states that essence of bailment is possession. He says that the possession of the truck was handed over to the DDA defendants when the truck was parked in the parking center of the DDA defendants. The defendants had issued a receipt and charged ₹3 for the safekeeping of the vehicle for a period of 24 hours. ₹3 for a day. Those days are well and gone, huh? 25, 26 years ago in Delhi. Immediately at that time, a contract of bailment came into being. The defendants as Bailee, having failed to deliver the vehicle back to the second plaintiff, the driver of that truck. There you go, that's the key part. The defendants as Bailee, having failed to deliver the vehicle back to the second plaintiff within the contracted period and not having shown to have exercised any prudent care for the safety of the truck, leading to it being stolen, are liable for the loss of the truck. It's immaterial the driver was also sleeping in the vehicle. The vehicle could not have been taken out of the parking center without surrendering the receipt. This is particularly so when the plaintiffs have submitted that the truck was under the charge, custody, control and possession of the defendants. It was not that the defendants had merely granted a license to the plaintiff to park the truck at any open space on a certain fee without there being any liability on the part of the defendants to look after the truck for its safekeeping. They basically undertook to look after the truck. That's the whole point of parking. Why don't you park on the road? Okay, you don't park on the road because you're afraid your car will get stolen. Therefore, you go and park in a parking center. If you're watching a movie, even if there's parking outside the mall, you will go and park inside the mall. You will pay the parking fees, however exorbitant they are, because basically the parking lot attendants representing the mall, the company that owns the mall, are giving you the assurance as Bailees of the goods and are bound under the terms of the contract of bailment, which arises under the Indian Contract Act, to take or exercise as reasonable care as an ordinary man of ordinary prudence in similar circumstances would. Therefore, Justice Wadhwa found that the claims of the insurance company and the claims of the second plaintiff, the driver in the truck, were correct. The suit was decreed for 2,91,500 with costs. DDA had to meet the costs of the truck, and the truck, I'm back on screen, which was lost due to the negligence of the DDA, would have to be compensated for. The loss of the truck would have to be compensated for to the tune of 2,91,500 rupees. Okay, so therefore, ladies and gentlemen, the big takeaway from this case is the moment the goods are in the exclusive possession, of the Bailee becomes liable for safekeeping of the goods. Okay, let's bring this point home with one quote from another case. It's on your screen. This is the case of Atul Mehra versus the Bank of Maharashtra, 2003. Decision of the Punjab and Haryana High Court. Straightforward stuff, guys. This refers to the rather interesting issue of bank lockers and what is the extent of the bank's responsibility for goods stored in these lockers. Okay, so in the case of bailment, exclusive possession of the property has to be given by the bailor to the bailee. We know that. Whatever property is deposited in the locker is undoubtedly in the custody and possession of the bank, said the Punjab and Haryana HC. Merely because the locker can be operated only in the presence of the locker hirer would not amount to joint possession of the locker. The banker can always open the locker with a master key. The hirer of the locker is not in a position to open the locker without the assistance of the bank. The hirer has access to the locker only during specified banking hours. The banker has no such limitation. He has a master key. It must, however, be noticed that the transaction of bailment would only be established if the provisions of Section 148 of the Indian Contract Act are complied with, and how did the plaintiffs comply with that in this case? How did Atul Mehra comply with the mandate of section 148? He led evidence to prove that the jewelry was actually in the locker on the date of the robbery, so the bank was robbed and the jewelry in the locker was robbed. The respondent bank could only be fastened, so important, with liability on the contents of the locker being disclosed to it. In the absence of this information, it would have to be held that there was no entrustment of the goods to constitute bailment. So therefore, if the plaintiff is not able to prove that he informed the bank that he was keeping jewelry in the locker, the respondent bank could not be fastened with liability, right? The bank tried to argue that they were in joint possession. That argument was rejected. They said it's not a question of joint possession. The locker is, and the goods in the locker are in the exclusive possession of the bank. However, it is incumbent upon the owner, or the hirer should we say, not the owner. The owner of the locker is the bank. It's incumbent upon the hirer of the locker, in this case Atul Mehra, to have informed the bank basically that I am entrusting the gold jewelry or diamond jewelry that I have stored in the locker to you, and then liability would be fastened on the bank. And therefore, exclusive possession, ladies and gentlemen, is a sine qua non for bailment. Okay, straightforward stuff. Read the facts carefully, pause it and read it. Let's go to the next slide. And delivery of goods. I told you we'll just wrap up with delivery, and we're wrapping up with that. The delivery of goods may be actual or constructive, and in this concept of delivery, I can also introduce you to another concept that we will be dealing with briefly in the next lecture, and that is the concept of a pledge. Okay, now what is the letter from the defendants in this case? So we're looking at the case of Bank of Chittor versus Narsimulu, 1966, Andhra High Court. The letter from the defendant reads as follows: I request you to leave the cinema projector and allied machinery pledged to the loan dated 19/9/1949 in my possession to run the cinema shows. I will hold the same to the bank in trust and will be prepared to give possession of the entire machinery to the bank whenever so demanded. So what happened in the case of Chittur versus Narsimulu? I'm back on screen, ladies and gentlemen. So a loan was taken out by Narsimulu. The loan was issued by the Bank of Chittor. Bank of Chittor creditor, okay, Narsimulu the debtor. Okay, as security for his debt, as collateral, what does he do? He delivers his cinema projection equipment. He runs a theater. He delivers the cinema projection equipment to the bank, and the bank is in exclusive possession of that equipment. But it turns out that he never physically delivered the goods. He simply wrote a letter stating that I hereby pledge all of my cinema equipment, the projector, etc., okay, to the bank as collateral, as security for the loan advanced to me by the Bank of Chittor. Okay, but physical possession remained with Narsimulu. He said in that letter, I request you to please allow me to keep possession of this equipment. Although it has been quote unquote pledged to the bank as collateral, as security, I need this equipment to run the shows, and the bank obviously agreed. The reason the bank is issuing the loan to you is so that you can carry on your business. They're not going to say, oh, here is a 10 crore loan. Give us all the equipment that you use to run your business. His business was the business of cinema. Okay. He was in the theater business. He owned a theater. So obviously it would be illogical for the bank to say, give us actual physical possession of all the equipment you used to run your business. So what happened in such a case? There was constructive delivery, and the banks were in constructive possession of the goods. Okay. How did the court arrive at this conclusion? Let's go back to the judgment. It's on your screen. Okay. So this is Chittur Narsimulu, Andhra High Court. Right. The court says, the delivery to the Bailee may be made by the Bailor by doing anything which has the effect of putting them in the possession of the Bailee or of any person authorized to hold them on his behalf. It is therefore not always necessary that the Bailee himself should be in physical possession of the goods. The bank need not be in physical possession of the goods. Delivering them to a person authorized to hold them on behalf of the Bailee is also sufficient delivery and constitutes a valid bailment. In the instant case, having regard to the language of Exhibit A3, that is the letter that I referred to earlier, okay, it must be held that there was a constructive delivery, or what is known as a delivery by atonement. That's a formal transfer to the bank. This is known as a delivery by atonement. You reproduce these words, you reproduce this quote in your exam. The examiner knows that, okay, this student, this individual who's writing the exam has done his homework. He has basically looked at the cases. Okay, he has used Sudhir Law Review, if I may pat myself on the back, and he knows his law of bailment, basically. Okay, so there is a constructive delivery or delivery by atonement to the bank. Since then, there was a change in the legal character of the possession of the goods, though not in the actual and physical custody. Even though the bailor continued to remain in possession, it was in the constructive possession of the Bailee. As it was in the constructive possession of the Bailee, we reject the contention that the bank did not obtain possession. So we reject the contention that the bank did not obtain possession. I hope that is clear. Now, I just want to move on to the next slide, okay, to wrap up this series of general principles surrounding bailment, and this is the issue of contractual and non-contractual bailment. Can there be a bailment outside of the Indian Contract Act? The short answer to that question is yes. Like in the case of contracts of indemnity, where Justice Chagla in Gajanan Mureshwar held that the law on indemnity is not exhaustive in the Contract Act. 124, 125 are not exhaustive as to the law of indemnity. Similarly, a bailment may arise outside the provisions of the Indian Contract Act. Okay, and I'm just going to read the part in bold, read the rest of the facts yourself. It says basically, bailment is dealt with the Contract Act only in cases where it arose from a contract, but it is not correct to say that there could not be a bailment without an enforceable contract. The Supreme Court observed, and this is in the case of Gujarat versus Memon Mohammad Haji Hassan 1967, referred to by the Delhi High Court in the case we have just done, that is New India Assurance versus DDA. What does Justice Wadhwa say? He relies on the observation of the Supreme Court that there was a legal obligation to preserve the property intact and also the obligation to take reasonable care of it so as to enable the government to return it in the same condition in which it was seized, and the possession of the state government until the order became final would be that of a Bailee. Therefore, what happened in Gujarat versus Memon Mohammad Haji Hassan, certain vehicles were seized by the custom authorities, and during the pendency appeal against that order, these were sold being unclaimed. Okay, an order of the magistrate was obtained under the old code of criminal procedure, and they sold goods that the custom authorities sold the goods that had been seized, but an appeal was pending. Then the appeal was decided against the state of Gujarat, therefore the goods had to be returned, right? The argument made by the state of Gujarat in that case was that, look, there was no contract of bailment, we seized these goods. We seized these goods because Memon Mohammad Haji Hassan was in violation of the law, or at least a violation of the law as we saw it. We seized his goods and we sold his goods. The Supreme Court said, no way, Jose, that argument will not fly. We cannot accept that argument. Why? Because there was a legal obligation in the state of Gujarat to preserve the property intact and an obligation to take reasonable care of the goods seized to enable the government, that is the government of Gujarat, to return it in the same condition in which it was seized and in the possession of the state government. Okay, until the order became final, and until the order became final, they could not have sold it. Because they sold it and then the order went against them, they would have to now basically make recompense, and they would basically have failed in their duty as a Bailee, okay, to keep the duty as a Bailee to basically maintain possession of the goods until the order became final. So this is a case of a non-contractual bailment. I don't expect you to be tested on this. Okay, so ladies and gentlemen, I'm back on screen. We've gone through a series of slides. I now want to move on to some ancillary provisions that deal with the duties of the Bailor and the Bailee. Okay, so let's start off with the duty of the Bailor. It's on your screen. So section 150, what is the duty of the Bailor? He has to disclose some faults in the goods bailed. Obviously, if you're going to impose a duty on the Bailee to take care of the goods, you must disclose any faults in such goods. Okay, so you leave a car with him, basically the car is broken down, the car is run down, the brake is unsafe, etc, etc. Okay, the car is in poor condition. Okay, you leave the car in the parking lot for 24 hours, then 24 hours later you come back and you say, oh, the car isn't starting, what has happened to the car, has somebody tampered with the car? You cannot blame the Bailee. Okay, you must disclose the faults in the goods bailed. Okay, so the Bailor is bound to disclose to the Bailee faults in the goods bailed of which the Bailor is aware and which materially interfere with the use of them or expose the Bailee to extraordinary risks. And if he does not make such disclosure, he is responsible for damage arising to the Bailee directly from such faults. If the goods are bailed for hire, the Bailor is responsible for such damage, whether he was or was not aware of the existence of such faults in the goods bailed. So A lends a horse which he knows to be vicious to B. He does not disclose the fact that the horse is vicious. The horse runs away. B is thrown and injured. A is responsible to B for damage sustained. Similarly, A hires a carriage of B. Let us say A hires a car of B, a rental car service. Let us say we have Zoom car. Okay, so A hires a carriage of B, Zoom car. The carriage is unsafe. The car is unsafe. Though Zoom car is not aware of it and A is injured, B is responsible to A for the injury. Pause it and read the section 150. I'm back on screen quickly to explain this. So let's take our Zoom car example. You rent a car from Zoom car. Okay, Zoom car is aware that in this car the brakes aren't functioning properly. You drive the car, the brakes aren't functioning, you get injured. Okay, the car gets damaged. Zoom car's car gets damaged and you are injured. You, let us say, break your hand, you fracture your hand in the accident. Zoom car has to make recompense to you, has to compensate you. Basically, Zoom car is to compensate you for the loss suffered, basically, and it becomes a tort. right? But it's essentially a tort because they've been negligent. But duties also arise out of contract, and it's easier to claim compensation as saying this is the case of a breach of a contract of bailment. The bailor has failed in his duty to notify me of the defects in the car, and even if Zoomcar was not aware that the brakes were not functioning, which is the most likely scenario, Zoomcar will more likely than not be aware that the brakes were not functioning, right? They won't be aware of that fact, and the brakes were in fact not, and as it turns out the brakes weren't working and you get injured and you break your arm. Even though Zoomcar had no knowledge, they were responsible for the general state of the car, basically. So they will have to undertake regular checkups, and I'm sure they do that on the car, get it checked every couple of days, each time it comes back from a rental or a hire. Okay, so these are the duties of the bailor. So what are the corresponding duties of the bailee? What are the duties of the bailee when he takes the car on basically hire? Okay, what are his duties? Let's go to the next section dealing with the duties of the bailee. It's on your screen. Okay, so the duties of the bailee are set out, all right, in 160, which we've already referred to. You must return the goods bailed on expiration of time or accomplishment of purpose. So the once your rental period expires in the car, you have to return it. And those of you who use Zoomcar know that when that purpose expires, right, and you don't return it in time, they will charge you an extra fee for late return. All of these are contracts of bailment. It is the duty of the bailee to return or deliver according to the bailor's directions the goods bailed without demand as soon as the time for which they were bailed has expired or the purpose for which they were bailed has been accomplished. Now, what are the responsibilities of the bailee? Okay, when the goods are not duly returned? If by the default of the bailee, the goods are not returned, delivered or tendered at the proper time, he is responsible to the bailor for any loss, destruction or deterioration of the goods from that time. So he is responsible not only for destruction or deterioration of the goods, but he's also responsible to the bailor for any loss caused. Okay, ladies and gentlemen, I'm back on screen. So let us say the goods aren't returned, the car is not returned in time. Okay, there is a penalty clause, that there is a penalty stipulation that Zoomcar imposes on the agreement that in the contract of bailment that they have entered into with you. They say each hour that you take to return the car, we will charge you 500 rupees. Okay, you return the car 30 hours late, so they will charge you 500 rupees per hour, right? So conceivably, Zoomcar could bring a claim and say that by delaying the return of the goods by 30 hours, you are in violation of their policy that all goods must be under no circumstances be returned no later than 24 hours after the expiry of the period. So let us say you have taken the car on hire for 48 hours, you return it after 49 hours. That's okay. They will charge you 500 rupees for that extra hour. But let's say you've taken it on hire for 48 hours and you return it after 73 hours. So that is 24 hours more. You've returned it 24 hours later, or in fact 25 hours later, more than 24 hours later, right? So 48 hours is the period of hire. You return it after 73 hours, more than 25 hours have passed. They said for the first 24 hours, we will impose a penalty for every 500 rupees. Okay, their contract is silent as to what happens in a scenario where you return the car more than 24 hours late. Let us say the contract is silent. In such a scenario, the bailor of the goods can conceivably rely on section 161, okay, to claim compensation and say that you've caused a loss to me because this car, okay, at the expiry of that 72-hour period, this car was to be handed over to another person who has paid me 10,000 rupees, okay, and I lost out on that contract because you returned the car 25 hours late. So the penalty only covered 24-hour delivery or return rather of the goods 24 hours later, but did not cover a scenario where the goods be returned 25 hours later. So you take it for 48 hours, Zoomcar says, sir, लीजिए यहाँ चाबी है, please 48 आवर्स में रिटर्न कीजिए. अगर 48 आवर्स के बाद आप रिटर्न करते हैं और आप लेट होते हैं, there is a penalty for each hour by which you are delayed. But sir, please note that under no circumstances can you bring the car back after 73 hours. You have a maximum of 72. 48 as per the terms of the contract of bailment, and another 24 if you return it, it will be 500 rupees per the 24 hours in delay. But if you return it to us, sir, after 73 hours, we reserve the right to claim compensation. And lo and behold, you return it after 73 hours, or let's say you return it after 75 hours. What has happened? The next person who had booked that car comes to the Zoomcar compound. He comes to take possession of his car. The car is not there. Zoomcar says, sir, we're so sorry, we'll give you a replacement. He says, no, I want that model. I wanted that Mercedes A-Class for rent. Okay, and you lose out on the 10,000 rupees, and then he also sues you in a court of law for breach of contract. That is, Zoomcar has breached contract. So Zoomcar could be hit with a hefty bill, and they can recover all of that from the bailee, because under section 161, the delay in return of the goods upon expiry of the time in which for which the goods were bailed has resulted in a loss to the bailor, that is Zoomka. I hope that's clear. Okay, let's look now at some more ancillary provisions that are on your screen. All right, so I'm looking at now a very, very important little concept of lien. Why am I looking at lien? Because a lien is referred to in section 170. I'll come to section 170 shortly, but first I want to explain what a lien is. Let me quote from the case of Syndicate Bank and Vijay Kumar, and it should become clear. Okay, you've heard of this term lien. Okay, especially in banking, the banks will say, sir, we have a lien on your funds deposited with the bank. Lien is in its primary sense a right in one man to retain that which is in his possession belonging to another until certain demands of the person in possession are satisfied. In this primary sense, it is given by law and not by contract. The passages go to show that by mercantile system, the bank has a general lien over all forms of securities or negotiable instruments deposited by or on behalf of the customer in the ordinary course of banking business, and that the general lien is a valuable right of the banker, judicially recognized, and in the absence of an agreement to the contrary, a banker has a general lien over such securities or bills received from a customer in the ordinary course of banking business, and has a right to use the proceeds in respect of any balance that may be due from the customer by way of reduction of customer's debit balance. Pause it, read it carefully. I'm back on your screen. So what do the banks say? Essentially, the banks are given what is known as a right of set off. So the bank has a general lien on all the money you deposit with them. Okay, what does the lien do? It gives the bankers a right of set off. And similarly, right, Baileys have a particular lien. Right, Baileys have a particular lien on the goods bailed to them. So my dry cleaner example is a very classic illustration of a lien that the dry cleaner has on that suit. Okay, so what does the dry cleaner say? Sir, I have dry cleaned your suit. You go to him, you say, how much to dry clean this suit? He says 500. You say, okay, you know what, I'm not that stingy, go ahead, dry clean the suit. He dry cleans the suit. He calls you up. He says, sir, it's now been 3 months, you have not come and collected your suit. He says, I have no interest in collecting that suit. Okay, so dry cleaner doesn't know what to do. He says, okay, he has no interest in collecting the suit. I have a lien over the suit. So he retains the suit. 3 months more pass by. He calls you and says, look, it's been 6 months. I'm going to sell this suit. You say, no, don't sell the suit. I'm coming. You come there and you say, okay, give me the suit. He says, okay, give me 500 rupees. Okay, you give him 500 rupees. Then he says, give me 5,000 more. You say, what do you mean give you 5,000 more? He says, yeah, give me 5,000 more because 5,000 rupees is the cost I've incurred in upkeep of this suit. Basically, might be an exorbitant sum, but who knows? Okay, let us say that it goes to court. The court says, yes, the expenses incurred by the dry cleaner in storing this suit for the 6-month period, 6 months after the period for which the contract of bailment came to an end, is 1,000 rupees. So he says to you, you have to pay 500 for the suit and you have to pay him a further 1,000 rupees, basically. Okay, so you then counter and say, but he retained the goods for 6 months. No, court will say he had a particular lien over that suit and he was entitled to retain those goods because of the bailie's particular lien. And this bailie's particular lien entitles the bailee to hold on to the goods bailed until and unless he has been paid. It's as simple as that. And if you never claimed the suit, the dry cleaner would have been well within his rights and say, this person has not claimed the suit for 6 months. I'm now going to go sell the suit. He sells the suit for 15,000 rupees. He's owed 500, he sells the suit of 15,000 rupees. Let's say his expenses are another 1,000 rupees in storing the suit and his expenses are another 500 rupees in selling the suit. He sells the suit to somebody in Delhi, he's based in Bangalore, courier charges, this, that. Couriering a suit is very expensive, by the way. So he spends about 3,000 rupees, 500 for the original cost of dry cleaning plus another 2,500 rupees to sell the suit, right? The goods bailed because the bailor shows no inclination of collecting the goods. Then the bailor says, where's my suit? He comes back after a year. He says, take a hike. I've sold your suit a long time ago. The bailor has the right to basically be compensated for the value of the suit, okay, and the suit will be valued. The amount at which he sold it will be certain, which would be say 15,000 he sold it for, 3,500 were his expenses. Let us say the value of the suit was in fact 15,000 and the dry cleaner sold it for the right amount, and therefore the amount of 11,500 rupees will be returned to the bailor. What the bailee did, absolutely nothing wrong in what the bailee did because of his particular lien that he had over the goods bailed, that is the suit in question. It's on your screen, 171, ladies and gentlemen. So 170, I beg your pardon. Bailey's particular lien. Okay, so Bailee's particular lien under section 170, right, where the Bailee has, in accordance with the purpose of the bailment, rendered any service involving the exercise of labor or skill in respect of the goods bailed, he has, in the absence of a contract to the contrary, a right to retain such goods until he receives due remuneration for the services he has rendered in respect of them. This is just a reiteration of what I've just said, and we can also refer to the illustrations under 170. If I said 171 earlier, I'm sorry, it's 170. Okay, A delivers a rough diamond to B, a jeweler, to be cut and polished, which is accordingly done. B is entitled to retain the stone till he is paid for the services he has rendered. A gives cloth to B, a tailor, to make it into a coat. B promises A to deliver the coat as soon as it is finished and to give 3 months credit for the price. B is not entitled to retain the coat until he is paid. Alright, now pause, read this carefully. I'm back in screen. So here, the contract terms override section 170 and precedence will be given to the contract terms. So here there is a credit facility, and a credit facility is given for payment. You have no right to retain the goods. Alright, it's as simple as that. So therefore, if the terms of the contract between the dry cleaner and the customer were that the customer would be given 10 days time to clear the bill of 500 for the dry cleaning, then there is no lien on the suit and the dry cleaner would have no right to retain the suit, despite the provisions of section 170, which gives Bailees a particular lien. So the long and short of it, ladies and gentlemen, is unless and until the Bailee is paid, he may retain the goods provided it is not contrary to the terms of the contract, and he may retain the goods because of the rights granted to him under section 170, that is a Bailee's particular lien. Now I want to look at the right to compensation. Okay, it's on your screen. Okay, if the Bailee, and this is again something I've alluded to when I gave my dry cleaning suit example, alright, the Bailee is entitled to certain compensation and also of course remuneration for the services performed. I'm looking at the case of Surya Investment Company versus Trade Trading Corporation, STC, 1985, decided by the Calcutta High Court. If the Bailee has to incur any expenditure for the preservation of the goods from deterioration not provided for in the contract of bailment, the Bailee will be entitled to recover such expenditure from the owner in as much as the owner will derive benefit therefrom if ultimately the goods are delivered to the owner. A Bailee cannot lose the possession as well as the charges for bailment. It is not a case where the Bailee has retained the goods as well as asked for charges for keeping it. Okay, that is the facts of STC. What happens in the case of STC? Right, special officer, okay, a special officer of the Surya Investment Company effected delivery of oils to the State Trading Corporation. Okay, and once that happens, the right of lien is lost to the petitioner in the case, that is the Surya Investment Company. A Bailee's right of lien arises out of his possession and is lost with the loss of possession. STC, after taking delivery of the goods, cannot contend that the petitioner is not entitled to claim rent or storage charges for the tank where the goods were kept. The petitioner cannot be denied its claim for storage charges solely on the ground that the petitioner has claimed or exercised the right of lien and therefore is not entitled to get any charge for keeping the goods bailed. Okay, read it carefully, pause it, read it. I'm back on screen. Back to my dry cleaner example. I'll use that illustration to explain what is being said in the Surya Investment Company and State Trading Corporation case, and then I will look at the facts of the STC case as well. What happens in the case of the dry cleaner? He has now sold the suit, right, for 15,000 rupees. It is not open. It is not open to the original bailor. That is me, the customer, who gives him the suit to say, hey, how can he claim charges for keeping the suit for 6 months? He exercised the right of lien, so he cannot claim charges for keeping the suit. Calcutta High Court rejected such an argument. The argument was made by Surya Investment Company. I beg your pardon. The argument was made by the State Trading Corporation. I beg your pardon. The argument was made by the State Trading Corporation against the Surya Investment Company. Certain goods were bailed to the Surya Investment Company. The goods bailed in that case were oils. Surya Investment Company took those oils and had to preserve those oils, had to take care of them, had to exercise the care of an ordinary prudent man, basically a man of ordinary prudence in similar circumstances. They had to do what he would have done. What would that man of ordinary man, what is that ordinary man, prudent man would have done in reasonable circumstances? He would have bought a tank to keep the oils. He would have ensured that the oils would not go bad. He would have ensured that the oils would not perish, basically. Okay, so this duty to exercise reasonable care is heightened when the goods are perishable. Okay, if it's fruits, if it's meat, perishable goods. So it's extremely important that you have to invest in a freezer. Yeah, things like that. You have to invest in a tanker to store the oils, which is what the Surya Investment Company did. Goods bailed to them by the State Trading Corporation. Okay, the goods were bailed to them. They stored the oils for X amount of time. Then they returned the oils to the STC. Once the oils are returned to the STC, the right of lien is lost. Once you return the oils, the right of lien is lost. Remember that. So once you return the suit, the right of lien is lost. The dry cleaner cannot claim that the bailor redeliver the suit to him because he has a lien over it. Once you have effected possession, the right of lien, once you have re-effected possession, let us say, you have redelivered the goods to the bailor, right, the lien is lost. So when the bank redelivers some goods that they have seized, okay, then their lien over those pledged goods, pledge is what we'll deal with in the next lecture, the lien over those pledged goods is lost. So this right of lien is tied to possession, but simply because the Surya Investment Company parted with possession does not mean that they cannot claim charges that they incurred for storing the goods bailed to them over and above the contractual period, over and above the period of the bailment under the contract. That is the thrust of Surya Investment Company versus Trade Trading Corporation. It's on your screen again. I want to reread it, the operative part. Yeah. A Bailee's right, okay, of lien arises out of possession and is lost with loss of possession. I told you that. The State Trading Corporation, after taking delivery of the goods, cannot contend that the petitioner is not entitled to claim rent or storage charges for the tanks where the goods were kept. The petitioner cannot be denied claim for storage charges solely on the ground that the petitioner has claimed or exercised the right of lien and therefore is not entitled to get any charge for keeping the goods bailed. You can, ladies and gentlemen, pause it, read it if you have to, I'm back on screen. You can claim both. What? You can exercise your right of lien by selling the goods in question, and you can claim the charges that you have incurred for storing the goods. But the moment you part with those goods, yeah, you have lost the right of lien, but you have not lost the right to claim the charges that were incurred, the expenses that were incurred for storing of the goods. So my dry cleaner could say, out of the goodness of his heart, he says, look, the bill was 500 rupees. I've had to store this suit for 6 months. Give me another 1,000 rupees as charges, and here are the charges. I'm giving you an accounting. He gives an accounting to the bailor of the charges that he has incurred in storing the suit. He says that every 1 week I had to brush the suit. I had to make sure the suit was in mint condition. This suit took up this X amount of space in my dry cleaning. I lost this business. All of those things considered, he arrives at the figure of 1,000 rupees for charges. Yeah, in such a scenario, the bailor is bound not only to pay the 500 rupees, which is remuneration, but also the 1,000 rupees, which is compensation for the charges incurred in keeping the goods bailed over and above the contractual period of bailment and taking reasonable care of the goods bailed over and above the contractual period of bailment. So now finally we come back to a little example I referred to earlier, also in my dry cleaner analogy, where I said that you go into the dry cleaner and you leave the suit on the counter. You leave the suit on the counter, you leave the suit on the counter, you're standing here, you're talking to the dry cleaner. Hello dry cleaner, here is a nice 3-piece suit. How much to dry clean this suit, dry cleaner? Dry cleaner says, hello customer, 500 rupees. Dry cleaner, are you out of your mind? No, I'm not going to give you 500 rupees, and you storm out. And you storm out in a huff, you're upset. Oh, you go home. Oh my God, I left the suit on the counter. Okay. The dry cleaner discovers the suit. What are the rights of the dry cleaner in such a scenario, and what are the rights of the customer? What is the right of the finder of goods, and what is the right of the person who has lost the goods? Let's go to the provisions that are on your screen. Really straightforward stuff, guys. Right of finder of goods, right, may sue for specific reward offered. The finder of goods has no right to sue the owner for compensation for trouble and expense voluntarily incurred by him to preserve the goods and to find out the owner. But he may retain the goods against the owner until he receives such compensation. That's a lien. That's another lien. So the right of finder also has a lien. And where the owner has offered a specific reward for the return of goods lost, the finder may sue for such reward and may retain the goods until he receives it, basically. So let's linger on 168. Okay, the finder of the goods has no right to sue the owner for compensation for trouble and expense voluntarily incurred by him to preserve the goods and to find out the owner. Pause. I'm back on screen. So dry cleaner sees, okay, he's left the suit here, the customer has left the suit here. He takes the suit, he stores the suit. He says, this guy didn't give me his name, he didn't give me his number, nothing. Okay, then he stores the suit. It takes him 6 months to track down the owner of the suit. He calls the owner of the suit. He says, hello buddy, I tracked you down. Remember 6 months ago you left your suit here? And you say, oh my God, I'm so forgetful. Did I leave the suit there? Oh no. Hey, you know what? I don't care about the suit. You keep it. The right of the finder of the goods, the dry cleaner says, what? And then he goes to a court of law and he sues you, the customer, for compensation. And he says, I've incurred all of these charges voluntarily. I've incurred all of these expenses voluntarily. Nobody asked you to keep the suit. Nobody asked you to track down the customer. Customer says, I didn't ask you to track me down. I didn't ask you to save the suit. Yeah, you found the suit. Keep it. Do what you want. Court will say, yep, Your claim is barred by section 168. Dry cleaner gets disappointed. Then he goes back to his shop. The next day the customer comes in and says, hey, you know what? I know you have my suit. Why don't you give me my suit? No way, says the dry cleaner. You want your suit back? I as the finder of goods have a right. I might not be allowed to sue you for expenses, right, that I have incurred voluntarily in keeping the suit, storing the suit, or the expenses I've incurred in tracking you down. And mind you, there were big expenses. I hired a private investigator to find you. Okay, I can't recover all these expenses, fine by me. You think I'm going to just give you the suit then? No way, right? But this is my suit, you say as the customer. Wrong, it's not your suit, right? Till what happens? It is your suit, you own the suit, but you don't have outright ownership of the suit. It is your suit, okay? But you don't have outright ownership of the suit. Your ownership is encumbered because of a lien that the finder of the goods has on the suit. He has a lien because he has undertaken expense to store it and to find you. Although he has done that voluntarily, till you compensate him for this, he has a lien over the suit and he does not have to return the suit to you. So what are your expenses, man? Look, I told you in court my expenses were 2,000 rupees. Okay, it cost me 2,000 rupees to store this. In that 1,500 rupees, okay, was actually, it cost me 2,000 rupees to store this and 1,500 rupees to pay the private investigator. So my total expenses are 3,500, but on the goodness of my heart, I will put aside storage charges, give me 1,500 rupees that I spent on tracking you down that I gave to the private investigator. He says, okay, here you say, here you go, here's 1,500 rupees. He hands over the suit to you. Right of lien is lost with possession. Okay, and under the terms of settlement, he has agreed to forego his expenses. So therefore, he cannot be allowed. And then it's the law of estoppel, right? He's estopped from asserting in a court of law that, hey, I also should get compensation. No, you have settled it for 1,500, settled, done. So the right of lien is lost once he gives the suit. If you go back to him and he say, give me the suit, he says, look, private investigator, 1,500 rupees, 2,000 to store it, and you say, what, 3,500 rupees for this piece of crap suit? That's 10 years old? No, thank you, I'll go buy myself a new suit. Till you pay him that compensation, he has a lien over that suit. Till you pay him compensation, he has a lien over that suit. And what then, sir, if he just sells the suit? Yeah, he exercises the right of lien. Despite repeated requests, you don't come to claim the suit. It comes to your knowledge that he has sold the suit for 15,000 and you say, oh my God, his expenses were just 3,500. Then you approach him and you say, I'll give you 11,500. And then you approach him and say, give me 11,500. Does he have to give you 11,500? Yes, he does. So you can then go to a court of law and say, 11,500 rupees are owed to me. 3,500 rupees are the expenses that he incurred in tracking me down and storing the suit. He has exercised his right of lien over that because I refused to pay him the 3,500. I found out that he has made a profit of 11,500. I am now entitled to that money, and the court will find in your favor because a dry cleaner is not basically allowed to profit. Okay, the finder of the goods is not allowed to profit. He is only allowed to be compensated to the extent of the expenses that he has incurred. That being said, okay, if you have lost a gold chain and you say the finder of this gold chain and the person who returns this gold chain to me will be given a reward of 1 lakh. Yeah, the finder of the gold chain comes to you, he says, here is your gold chain, the reward is 1 lakh, give me the 1 lakh. If you refuse to give him the 1 lakh, he still has a lien over that gold chain. He has a lien over that gold chain till the 1 lakh or reward is paid. That is what 168 says. Let's go back to it and all will become clear. It's on your screen, okay? Right of finder of goods may sue for specific reward offered. The finder of goods has no right to sue the owner for compensation for trouble and expense voluntarily incurred by him to preserve the goods and to find out the owner. We know that. But he may retain the goods against the owner until he receives such compensation because he has a lien over that good or those goods, and where the owner has offered a specific reward for the return of goods lost, the finder may sue for such reward and may retain the goods until he receives it. Okay. Now 169 deals with whether the finder of the thing commonly on sale may sell it. The finder is not, okay, found the owner. Okay, the scenario now is different under section 169. The finder has not been able to track down the owner. What happens when the finder cannot track down the owner? Can he sell the goods lost that are now in his possession? The goods lost by the original owner which are now in his possession. When a thing which is commonly the subject of sale is lost, if the owner cannot with reasonable diligence be found, or if he refuses upon demand to pay the lawful charges of the finder, the finder may sell it. Okay, so we have two scenarios, one of which we've already alluded to in our dry cleaning example, where you say, take a walk, I'm not paying your compensation for storing this piece of crap suit. When a thing which is commonly the subject of sale is lost, when thing which is commonly the subject of sale is lost, if the owner cannot with reasonable diligence be found, or if he refuses upon demand to pay the lawful charge of the finder may sell it. When the thing is in danger of perishing or losing the greater part of its value, or when the lawful charges of the finder in respect of the thing found amount to two-thirds of its value, when the lawful charges of the finder in respect of the thing found amount to two-thirds of its value. I hope this is clear, ladies and gentlemen. If not, I'm back on screen to explain. So what does 169 say? You find the suit. You have no way of tracking down the owner. You may sell it if basically the good is such a nature that it will lose its value with time. So if it's a good of a perishable nature, it will lose its value over time. It need not necessarily be perishable. A suit will not perish. But the older the suit gets, the more it loses its value. Right? People say the more you dry clean a suit, the more older it looks, the more it fades. So they say don't dry clean it too much. The value of the suit lies in its appearance of it being crisp, of it being new. So the finder of the goods, he finds the suit, he says, this guy just stormed out, I have no way of tracking him down. I cannot track him down with reasonable diligence. Hiring a private investigator is way above the requirement of reasonable diligence. The reasonable diligence is if this guy gives you his name and number, you exercise a reasonable diligence, you call him and say, hey, I found your suit. But he does not give you name and number, you don't know who he is. He walks into your store, leaves a suit, fights with you and leaves by leaving behind the suit. You cannot find him with reasonable diligence. So under 169, you may sell it if the thing may lose its value. Alternatively, the owner has been found. Like in my earlier illustration, you've called the owner. You've said, I found your goods, man. I found your goods. It's taken me 6 months to track you down. 1,500 for private investigator, 2,000 rupees to store it. Pay me 3,500, I'll give you the suit. Otherwise, I have a lien on the suit. What does the owner say? Take a hike. I'm not going to pay you. Okay. Then the Bailee in that case, right? It's not a Bailee, I beg your pardon. The finder of goods. See, this is how you can so easily get confused. There's no bailment here. They're known as finder, right, of the goods and the owner. Okay, the requirements of a bailment obviously are not satisfied. There's no voluntary delivery of goods. There's no voluntary handing over of exclusive possession from the customer to the dry cleaner here. But it draws its thrust from the general principles of bailment, right? These provisions. Okay, so the finder of the goods may sell the suit provided his charges, his lawful charges amount to two-thirds of the value of the suit. Therefore, if the value of the suit is 15,000, basically, can he sell it? If the value of the suit is 15,000, can he sell it? The answer is no. Because his lawful charges are only 3,500 and at the most that amounts to about 1/4 of the value of the suit and not the required 2/3. Therefore, he may only sell the suit if his charges for keeping the suit amount to 2/3 of the value, which means that if his charges for keeping the suit, right, amount to more than 10,000 rupees, that's more than 2/3 of the value. That's more than 2/3 of the value of the suit. He may sell it. And out of that, he may retain the amount of charges. So he sells it, his charges, it takes 5-6 years, his charges are now 10,000 rupees. The suit is worth 15,000 rupees now. So he says, my charges are now 2/3 of the value. He sells it, 5,000 remains, he takes 3,500, right? He has an extra 1,500, which the Bailor has I beg your pardon again, the owner of the goods has the right to recover. He may recover only the 1,500. Okay, so in my earlier illustration, if I've blatantly, flippantly said that, yeah, he sells it for 15,000, his charges are 3,500 and then he returns 11,500 to the owner, that can only happen if the first limb of section 169, that's 169 subsection 1 is satisfied. But if subsection 2 applies, he may only sell it if it is up to 2/3 of the value of the goods. I'm going to go reread that Bare Act provision, section 169, and all will become clear. It's on your screen. Okay, when a thing which is commonly the subject of sale is lost, that's a suit. A suit is commonly the subject of sale. Of course it is. If the owner cannot with reasonable diligence be found, or he refuses upon demand to pay the lawful charge of the finder may sell it when the thing is in danger of perishing or of losing the greater part of its value, or when the lawful charge of the finder in respect of the thing found amount to 2/3 of its value. Pause it, read it carefully, 169. I'm back on screen to wrap up. So simply put, ladies and gents, he may sell the suit for 15,000 even if charges are 3,500 if the suit is in danger of perishing. if the value of the suit is in danger of depreciating rapidly. So the courts would probably find no way, come on, a suit is not a perishable good. So it's really a question of how the civil judge in that case will decide on the facts, because what he will adjudicate on the facts. But a more sure footing on which the dry cleaner, that is the finder of the goods, can sell is if his lawful charges amount to 2/3 of the value of the suit. So moment it crosses 2/3 of the value of the suit, his lawful charges for keeping the suit, or that can also include the efforts that he has taken to find the owner. He has found the owner and the owner says, I'm not interested in the return of the suit, you can keep it. Then the finder of the goods still has to meet the requirements of 169(1) and 169(2). So therefore, what is the moral of the story? If you find something on the street, just wash your hands off of it. Yeah, this is what our quote-unquote elders tell us, right? Hey, you find something, don't be a good Samaritan. You find gold, you find jewelry, don't take it. God knows what trouble comes with it. Yeah, that's kind of our approach, right? We don't want to get caught up in this web of litigation arising out of the goods that you find. Okay, so it might very well be good advice, right? Listening to your elders might work, because when you find goods, you have various rights, but it's a pain in the backside for you. You can only sell it if your charges amount to 2/3 of the value, or if that good is a perishable good, or it's going to deteriorate in value. So therefore, if it's gold, you could argue that it's deteriorating in value. Okay, and if the owner cannot be found, yeah, and you sell the gold, the court will then determine upon the owner coming forward whether the owner could have been found with reasonable diligence. And if they find that you didn't exercise reasonable diligence, they can consequently make an order against you. Okay, so this is the rights of finder of the goods. Okay, and although we don't use the terms Bailee and Bailor here, the owner and the finder are in a similar sort of relationship. There is a lien on those goods found until and unless the owner clears the lawful charges incurred in finding him and the lawful charges incurred in storing the goods found by the individual who found them. I hope that's clear, ladies and gentlemen. One last slide left in this lecture. I know it's been a lengthy one. There's one last slide left. Let's go to that to wrap up this lecture. It's on your screen. And this is where a third party enters the picture, and a third party causes damage to the goods bailed. Not the bailor, not the bailee, but a third party. Okay, so section 180, ladies and gents, is what I am referring to here. Okay, that's on your screen. Suit by bailor or bailee against a wrongdoer. All right, if a third person wrongfully deprives the bailee of the use or possession of the goods bailed or does them any injury, the bailee is entitled to such remedies as the owner might have used in the like case if no bailment had been made. And either the bailor or the bailee may bring a suit against a third person for such deprivation or injury. Pause 180, read it, I'm back on screen. So going back to our New Assurance Co. Limited versus Delhi Development Authority case, let's say that the bailor and the bailee find out, thanks to the help of the police, they find the person who has stolen the truck. But lo and behold, Justice Wadhwa's order has already been made and the Delhi Development Authority has paid the amount of rupees 2,91,500 for the theft of the truck. They have paid that amount to the bailor. The bailee may sue that third party civilly. In a civil court of law, he may sue the third party to recover the amount. The man might have been a common thief who stole the truck and he might not have any deep pockets. But whatever he has, the bailee will sue him to recover in a court of law. And of course, right, for that theft of that movable property, the individual will of course go to jail and he will be proceeded against under the provisions of the Indian Penal Code. So that is what section 180 says. It brings in third parties into the fold, and any wrongdoing leading to the deprivation of the goods or possession of the goods of the bailors, leading of the goods bailed to the bailee by the bailor, will lead to the bailee proceeding or being given the right to proceed against a third party, and so does the bailor. The bailor also will have the right to proceed against a third party. And those of you who've done your CPC, who know your CPC, who've looked at SLR's lectures on the CPC, know that in such a scenario, even though the bailor has been paid the amount of 2,91,500, he will be impleaded as a necessary party. Yeah, this is this lectures on joinder of parties. He'll definitely be a necessary party to that case, right? It's good practice to include him as a necessary party. And if you don't include him as a necessary party, at the very least, you will call him as a witness during the trial, wherein he will attest to the fact that he was paid 2,91,500, okay, because of the theft of the truck. Okay, and now we like to proceed against the individual that the police have discovered actually stole the truck. Okay, and the last section of this lecture, finally, in section 181 is on your screen. What does it say? Apportionment of relief or compensation obtained by such suits. So how is the relief or compensation divided or apportioned between the bailor and the bailee against the third party. Whatever is obtained by way of relief or compensation in any such suit shall, as between the bailor and the bailee, be dealt with according to their respective interests. So, ladies and gentlemen, it's a very practical provision. It shall be dealt with according to their respective interests. Let's look at the case of Purushottam Das Union of India, small little court, decision of the Allahabad High Court handed down more than 50 years ago. We have no doubts at the Allahabad HC in our mind that the bailee is competent to file a suit for recovery of the goods fraudulently or forcibly taken out of his possession by persons without title. What is apparent in the facts of this case is that while the plaintiff was in lawful possession of the goods as bailee, possession of the same was by an act of fraud taken by defendant number 3. Yeah, it could not be urged with any force that the railways of the bailies whose lawful possession had been wrongly disturbed could not recover the goods from defendant number 3. So much like in DDA, the DDA case, okay, and I'm back on screen, much like in the DDA case, if the thief can be found out, and that is the role of the police, the thief can be proceeded against in a court of civil law, and he will be proceeded against under section 180, and when the order is made, the apportionment of the amount that is decreed against the third party for depriving the bailee of possession will be apportioned according to the respective interests of the bailee and the bailor. Even if the bailor is impleaded as a necessary party, he will not be entitled to any compensation, any money. Why is that? Because he has already been paid the full amount of 2,91,500 by the DDA, and therefore, right, the DDA will have judgment for the entire 2,91,500, and that's what 181 says. Apportionment of any relief or compensation awarded when a third party is the wrongdoer and has deprived the bailee of possession, right? The bailee will basically be entitled to relief, and he may sue the third party as though it is the bailor himself who is suing the third party. And ladies and gentlemen, with that, we come to the end of our lecture on bailment. This is the sample lecture of the course. I hope you've enjoyed it, and if you have, I'd urge you to subscribe to the lectures on the law of contract part 2. And in the next lecture, for those of you who have already subscribed, in the next lecture, we will deal with the concept of pledge.